Hi, everyone. Welcome to our fifth webinar. As usual, let's start from checking the connection and all other technical matters. So if you can properly hear me and if you are able to see the screen with my slides, please send the plus to the chat. So I'll be sure that the connection is good and that we will be able to have a productive conversation today and a productive presentation as well. So our main today topic is about the fundraising for the Web3 projects. And from my perspective, this is a very good chance to remind what we discussed previously. But before we start, again, I would like to double check the connection and be sure that it's good. So please send the plus to the chat to help me to understand that all our technical matters are properly set up and that we are able to continue. Before I receive this confirmations from you, I'll also provide some brief overview of today's presentation. So our main topic is about fundraising for Web3 projects. And this topic will mostly cover all matters that are related to the documents with the investors, the matters which are related to the due diligence, and the matters which might be related to some questions about the valuation of the Web3 startup, as there are some differences that might be that should be taken into account when considering the Web3 fundraising. As usual, we will split our webinar into two parts. The first part will be more the content part, and the second part will be the Q&A. So please feel free to send your questions into the chat. And let me take a few minutes to double check with the team whether the connection is good to be sure that all is properly set up. 1 second. So thank you again for this time, and it seems that all is good with the connection, so we can continue. As I mentioned, this topic today is about the Web3 fundraising, and this is a really good chance to briefly remind what we discussed previously on our previous webinars about the DEP's legal structuring, about the intellectual property and developer registration, about the tokenomics, token cap tables, Web3 products, and the legal compliance for them, etc., etc. As all these matters are super important when it comes to the investor's due diligence and when it comes to also the investment documentation preparation, as all these important details of the Web3 startup usually should be included into the investment documents, as this is one of the requirements of the investors. And we will definitely cover it during our today's webinar. But before that, let me make a brief introduction of myself. My name is Nestor. I'm an international legal specialist working with the blockchain companies since 2015. Since that time, I conducted the hundreds legal sessions with the Web3 founders and collected some use cases, which I'll be happy to share with you today. Apart from it, I'm also a contributor for the Legal Notes Resource Center. I write about different legal concepts for the Web3 industry. So you are very welcome to visit our website and go to the Resource Center and find more articles and more information with the charts and the comparison tables, which are related to different legal matters in the Web3 industry. Apart from it, just a few words about Legal Notes, as this is the platform where the founders are able to solve their cross-border legal tasks in a single window. We are covering more than 15 countries and working with more than 100 legal professionals which are locally qualified and who have a really good experience in the tech and Web3 area. But this service will not be possible to provide for us without the virtual legal officer, who is the core person in this process and who acts as the dedicated legal manager for the founders and who facilitates the process of engagement of the most relevant local lawyers from different countries and areas of law. And basically, the virtual legal officer helps the Web3 founders to navigate around different regulations and different regulatory frameworks around the world, try to find the most suitable solutions for their international projects, and engage the local legal providers to receive a proper local legal advice, register local companies, and also solve any other local legal matters in different countries and with this cross-border element. So if you might be interested in such kind of service, please feel free to visit our website, legalnotes.com, and there will be more information about the virtual legal officer and generally about the legal notes services. Another important disclaimer is about the legal advice, that this presentation and all information that you might find on the slides and on Legal Notes website, including our resource center, is not a legal advice. So please consider it just for the informational purposes. And as always, we would like to remind that for specific legal cases and specific legal matters, it's necessary to obtain a proper local legal advice from the regulated legal professionals, from the qualified lawyers. And again, if you need the help with this, please feel free to book the call on Legal Notes website, and we will be able to help you with this. So, coming back to our main topic about the Web3 fundraising. The question which I would like to use to start our conversation is about the difference between the Web2 and Web3 fundraising. And the main difference from the legal perspective is with this core asset for the company's valuation. For Web2 startups, this core asset is the company's shares. And the general idea and the main goal for founders, for the team, and for the investors is to grow the valuation of the company's shares. And as this might be usually done by growing the company's metrics, the company's awareness, the revenue, the team, and the impact onto the market, etc. It's a bit differently, it works a bit differently in Web3 startups, as all these metrics related to revenue, awareness, impact, etc. are important in the same way. But the core asset is different. It's more about the tokens, which is the asset which helps Web3 founders to build a community, to grow the number of people who would like to use the service and who would like to get this additional motivation for using it in a more proper way or in a more active way. So that's the main difference between the Web2 and Web3 startups. And at the same time, this is something that shapes the expectations of the investors. And considering that the investors' expectations is one of the core points when it comes to the fundraising legal structuring, this is something that we will discuss deeply today and clarify what is the main difference between the Web2 and Web3 fundraising from the legal perspective. Speaking about the legal perspective and the legal matters at all, when it comes to the fundraising, it doesn't matter what is the stage of the fundraising. The investors will always ask about the core legal matters of the project and of the company. And these core questions will include the question about the company, whether it's registered or not, the question about the documents, the questions about the compliance, about the due diligence, about the team, the intellectual property, etc., etc. And that's something that usually requires from the startup side, solving these core questions to be prepared for the fundraising. These questions from the Web3 perspective might include the SAFT preparation and some important details that should be included into this kind of document. The Web3 company, the company registration for Web3 fundraising, and we will briefly discuss which kind of companies might be used for specific stages of Web3 startup fundraising, and also about some specific documents which might involve not just the tokens but also the equity. And there will be a much more interesting questions related to the governance, as in the traditional Web2 startups, the most of investors would like not just to receive the part of the shares, but also to take some part of the control over the company, because that's some kind of guarantees for the investors. At the same time, it's a bit different in Web3 because the end goal of the Web3 founders is to transform the Web3 project into the decentralized autonomous organization. And we will also cover a bit what are the consequences of this concept for the legal side and from the legal perspective of the fundraising legal structuring. So that's the here we have the agenda slide, and that results the questions that I would like to discuss today as the agenda, on our agenda. The first is the fundraising stages, as this is very important to understand which kind of documents and which level of legal due diligence investors will do on each stages of Web3 project development. Secondly, we will discuss the specific documents and specific legal matters which the investors usually ask on different stages of Web3 fundraising. The next, we will discuss the investment documents, because that's the next stage after the due diligence will be completed. And the last question, which I would like to discuss with you today, is about the valuation. And that's something that we started from, that's something that we briefly discussed or covered at the start of this webinar, and which is related to the Web3 startup valuation. So let's start. The first question is about the fundraising stages. Let's start from a more general overview of the fundraising process, which usually consists of 3 stages. The first stage is the negotiation and the term sheet. Basically, it's more like a business stage, because the investors and the Web3 founders need to discuss a lot of a lot more other details related to the Web3 startup, to the Web3 startups team, to the Web3 startup solution, including all technical details, etc., etc. And in case there is some connection between the investor and the Web3 founders, and there is there are the feelings that they can cooperate between each other and build together a big company, they are ready to move to the term sheet, which is basically a very general document which includes that every fundraising starts from. The next stage is about the due diligence. After the founders and the investor sign the term sheet, they move to the due diligence stage, where when the investors, lawyers, or investors' legal team send the list of legal questions to the Web3 founders and ask to clarify some important questions about the Web3 startup. We will cover these questions a bit later. And after the due diligence stage was completed, the investors and the Web3 founders moved to the investment deal and sign the investment documents, and the investors from their side make the investment transfer, and the founders receive the transfer and start using this money for building their company. That's the structure that I would like to. Here you can see these different stages of the Web3 product roadmap. So it's more like a business stages, where the first stage is usually about the product and protocol development. It also includes the team building and find the right advisors. So it will also be included here. The second stage is about token launch and token distribution. And the third stage is about the ownership and governance decentralization. And this stage includes all DAO related matters of the Web3 project development. It's very important to define briefly which kind of fundraising stages are connected to each of these stages from the Web3 product roadmap. Speaking about the first stage, which is a product and protocol development. On this stage, the founders usually raise pre-seed or seed investment round. It will have some legal implications considering the type of the legal entity and the type of the documents that might be used on this specific stage. On the stage of token launch and token distribution, there might be more mature fundraising stages like Series A, B, C, etc. And on the stage of the ownership and the governance decentralization, it's more about the token distribution by DAO, and that's something new and completely different from the Web2 fundraising, and we will also cover it a bit later. So next question, and the next part of this table that we are discussing now is about the companies. That's the first question that the investors usually ask the founders when it comes to the discussion of legal details of the founders project. Basically, this question is, which kind of company do you plan to use to close this fundraising round? And for each stage of this Web3 product development, there are different kinds of legal entities. We have previously discussed on our earlier webinars the dev company as the company which covers the team building, the operating matters, hiring people, developing the solution, Web3 product, protocol, smart contracts, and also as the company which holds IP. Secondly, when we discuss the tokenomics and token distribution plan, We also covered the token company, which is the company which is responsible for this all token-related matters, how to issue the tokens, how to distribute it in the compliant way, in both pay and unpaid way, and which kind of other regulatory compliance matters should be followed by this company when it comes to token launch. And the DAO company, which is something new, and which we will discuss in details on our last webinar, which will be on this Thursday. So please feel free to come. You're very welcome. And we will discuss very interesting concept there related to the DAO companies and to the DAO building at all, of course, from the legal perspective. So here you can see this different Web3 product development stages, also different fundraising stages, which are linked to each of the Web3 product development stage. And lastly, you can see the types of the legal entities from this triple companies model, which we discussed on our very first webinar about the DEP's legal structure. And the next question, as we discussed previously, is about the due diligence. So which kind of legal information and legal documents the company and the founders need to prepare on each of these stages to successfully go through the investor's due diligence and to be prepared for the investment deal. First of all, let's focus on this first stage, which is Web3 product and protocol development. As was mentioned previously, the core legal entity on this stage is a DevLab company, which is basically the company which covers the operating matters and holds the intellectual property. And that's something that should be taken into account when preparing this company for the fundraising, as this company probably will be used on the early stage of Web3 project fundraising, on this pre-seed and seed stages. This due diligence information will include the dev company cap table, or basically the shares split between the founders and the team pool. Also, there will be the documents related to the team, how the team members are hired, whether all documents are properly signed with these team members, whether the team members have any share options in this dev company as the part of the share incentive scheme of the company, etc. And the third part of the due diligence of this dev company is the intellectual property protection. And this question will include the IP assignment agreements, the NDAs, trademark registration, patents registration, and probably some other IP-related matters. After the founders complete the due diligence stage, they might move to the investment stage. And when we speak about the investment documents, specifically for this early stage of Web3 project development, we can speak about the traditional equity convertible instrument. It might be SAFE, it might be advanced subscription agreement. It also might be convertible note or any other convertible instrument, plus token warrant. And token warrant here is something new, which is completely different from the Web2 fundraising, which I would like to discuss with you in more details on the following slide. Basically, the token warrant is the very simple annex to the main convertible instrument, to the SAFE or convertible note or advanced subscription agreement. And the main idea of this side letter, of this annex, is to reserve the right to receive the tokens in the future for this SAFE or convertible note investor. That's usually the requirement of the investors who would like to invest into the Web3 companies. As on such an early stage, both investors and the founders might not be 100% sure that they will issue the tokens in the future. However, if this token issuance and distribution event will come into force in the future, the investors would like to have this guarantee or this right to receive at least part of these tokens that might be issued in the future. As there might be the situation where the tokens will become the core asset of companies of Web3 projects valuation, and then the tokens will be the asset that will provide the investor with his or her own investment returns. And speaking about the clauses in the token warrant, this kind of instrument usually includes a very general formula of how the tokens might be calculated if they will be issued in the future. Just a general idea or just an explanation of the part of these tokens or the formula which helps to calculate how many tokens the investor will be entitled to receive if the Web3 founders will decide to issue the tokens in the future. So that's about the token warrant, which is again the annex to the traditional equity convertible instrument, and which is usually used on this early pre-seed or seed stages of the Web3 project fundraising. Let's move to the next stage. The next stage is the token issuance and distribution. And as we discussed previously, usually this stage, product development stage requires more funding to cover some marketing plans, to cover some other very important matters for growing the community, for making some PR campaign around the company, the token, and also to make a lot of technical developments, including the tokenomics development as well. That's why at this stage of token issuance and token distribution, usually more funds are needed, and that's why at this stage more mature investment rounds are usually conducted by the Web3 founders. Among these investment rounds, we can speak about the round A, round B, round C, and even more later rounds of investments. And the very important stage, which we discussed at the start of this webinar, on each of the fundraising in each of the fundraising campaign is the due diligence. Speaking about the second stage of Web3 product development, which is about the token issuance and distribution, we need to discuss the following legal matters for completing the investor's due diligence on this certain stage. The first one is related to the token cap table. The investors will need to understand what are the pools, token pools, what are the token allocations, and also what is the token distribution plan, how the tokens are planned to be distributed for each of categories of Web3 product ecosystem participants, and also what will be the way of this distribution, whether it will be paid or unpaid token distribution, etc., etc. So all these matters are usually included into the tokenomics, token cap table, and token distribution plan. So that's something that all investors will ask on this specific stage of the fundraising. Secondly, it will be very important to prepare a token legal opinion to provide the investors with the confidence that there will be no legal risks and legal obstacles for issuing such tokens and listing these tokens on different exchanges, wallets, and other liquidity providers' platforms. And the last one is related to the authorizations and licenses. This is something that we covered on our previous webinar about the tokenomics and token distribution. Depending on the way how the tokens are planned to be distributed, whether it will be the private token sale, airdrop campaign, staking rewards, or some other way of token distribution, it will be very important to double check whether there might be some requirements to obtain the specific authorization or license for this each way of token distribution. And this is also something that investors will ask about, because the investors will need to be 100% sure that the money that they will invest into the Web3 startup will not be spent for paying some fines or for covering some legal spending for some court proceedings, etc. That's why for the investors, it will be very important to check all the regulatory compliance matters on the stage of token issuance and token distribution. Speaking about the legal document that might be used for this specific stage, we can discuss SAFT, which is a simple agreement for future tokens. And SAFT is the document which might be signed on these later stages when the the tokenomics is already developed, and where all important token-related details might be reflected in the SAFT agreement. Speaking about these details, we can highlight the total amount of token issuance, the token price, the token pools, some token distribution plans and stages of token distribution, also some vesting or lockups which might be implied to some specific transactions with the tokens in the future, and also the conversion event. This conversion event is the moment or the stage of the Web3 product development when the SAFT should be converted into the tokens and when the tokens should be transferred to the investors. So that's why we can call SAFT as also some kind of convertible instrument, but it's not like an equity convertible instrument for the Web2 startups, but rather the token convertible instrument as for the Web3 startups. So that's the main difference between these two documents. And as all these token-related details are super important for the SAFT preparation, it might be possible to sign SAFT only if the token company is already registered and only after all regulatory compliance matters are completed regarding the tokens, like obtaining token legal opinion, obtaining some authorizations or licenses for token issuance and distribution, and also providing all this information for the investor to complete this due diligence stage. So that's about the SAFT, which is a document for the second stage of Web3 product development. And we have also this last stage of Web3 product development, which is more about the ownership and governance decentralization. Speaking about this ownership and governance decentralization, that's the stage where the DAO comes, and this concept is, or this stage is not obligatory for all of the Web3 founders. It's not necessary for all of the Web3 founders, and only the Web3 founders who decide to transfer their ownership and their control over the project and over the company to the community will launch this DAO in the future. So that's the very important also question for discussion when it comes to the preparation of the fundraising strategy of a Web3 startup. Speaking about this specific stage of fundraising, we cannot say that there are some shareholders or there is a board of directors who might make who will be entitled and who will be responsible for the decision whether or not to issue the tokens and to issue some probably additional tokens for the new investors and conduct some new fundraising campaign. At this stage, it might be done by the DAO community. So the DAO members will probably vote whether the DAO needs more money and whether it might plan to issue some additional tokens and raise investments to increase its own treasury and to scale faster and grow the community and the protocol. On this stage, speaking about the due diligence process, the investors will probably be interested in DAO constitution, as this is the document which regulates the DAO governance. investors on these later stages will be aware of their role in the DAO. So they will probably become the DAO members with their stake of tokens and with their rights to vote, or probably to participate in some DAO governance body. And on our next webinar on the Thursday, we will discuss a bit more about the structures of DAO governance bodies, how which kind of this bodies the DAO might include, and like how they can. What might be the relationship between each of these governance bodies inside the DAO. Secondly, the investors will need to understand the requirements to become the DAO members, because again, for the most of the investors, it will not be enough to receive just the tokens. The second very important question that investors usually ask is about the control and their guarantees and the right to participate in the company's management and the company's governance. Considering that on this third stage of Web3 product development, that there is no centralized governance, there is no centralized board of directors or general meetings of shareholders, the investors would like to understand how they can become a DAO members and how they can participate in this decentralized governance being a DAO members. So that's the main question which will be related to the DAO membership. And finally, the KYC and AML compliance, which are super important for each DAO when it comes to the to spending of some assets from the DAO treasury to some market participants. So that's also something the investors will check on this due diligence stage. Speaking about the legal document on this stage, it will be very important to for the DAO members to decide which kind of legal document the DAO company will need to use to properly transfer these tokens to the investors. Also to conduct a proper due diligence of investors from the DAO side, because that's also a very important stage. And also to check and verify the investors and their source of funds, etc., which is basically included into the token sale or token transfer agreement, which might be signed between the DAO company and the investors. This token sale agreement is the document which is usually like governed or which is usually structured according to the intention of the DAO members. As we should remember that on this stage, on this final third stage, after the DAO was launched, the DAO members are responsible for these strategic decisions, whether or not to sign some specific documents for which might require the issuance of some additional tokens or some additional allocations of tokens from the DAO treasury. That's why some of the very important clauses and the details of this token sale agreements might require to be proved by the DAO members, and after that the DAO representatives might sign it from the DAO company. And this is very important to highlight that DAO company usually acts as the governance wrapper in this transaction, as the tokens on this stage is usually fully on chain, which means that there is a fully on chain treasury. There are some specific rules that clarify how these tokens should be distributed, and all these rules are incorporated into the decentralized ownerless smart contracts. So the role of the DAO company in this process is to first cover all compliance matters, and secondly to sign the agreement as in a role of the governance wrapper, in a role of the legal representation of the community of these DAO members. And that's very important to reflect in these documents and communicate with the investors on these later stages of token distributions and token sales for the investors. Secondly, that the proceedings from this new token allocations and token sales usually come to the DAO treasury. And again, this DAO treasury is also managed in a decentralized way, where the DAO members are entitled to vote how they would like to spend this DAO treasury, whom they would like to send the grants to support some ecosystem projects, or which kind of services they would like to pay to grow faster, to grow their community faster, or to make some improvements into the protocol, etc., etc. And basically, these token sale agreements might also include the lockup clauses and lockup requirements and mechanics to keep the tokenomics in order, as these big allocations of tokens might have some like negative consequences for the token price in the future. So it should be balanced by these different vesting and lockup schedules and the mechanics to ensure that tokenomics will work in a proper way in the future. So that's about this 3 stages of Web3 product development: the stage of Web3 product and protocol development, the stage of token issuance and distribution, and the stage of DAO launch, which is about the decentralization of management and ownership. And each of the stages has its own package of legal documents and legal works that should be done to complete the investor's due diligence. And secondly, each of the stage has its own type of investment documents that might be used to raise investments from the Web3 venture firms. That's the summary of this part. And we are able to move to our last question, which is related to the token, to the Web3 valuation, Web3 fundraising valuation matters. This valuation matters might be related specifically for the core asset of the project. And at the start of this webinar, we discussed that it might be token, it might be equity, it might be both token and equity. And that's the question which also results some other question, where it's important to register the DAO company, or what might be the consequences of registering the token company before token launch, DAO company before token launch and after token launch. Speaking about the DAO company registration before token launch, we can say that there probably might be some lack of decentralization, as before the token launch, there is no this huge community of people, or this big community of token holders who might be motivated to be involved into the project and participate in this decentralized governance. That's why until the tokens will be issued, this will be probably quite a small community of people who might be involved as the DAO members into this DAO decentralized governance. That's why DAO company registration before the token launch might result some lack of Web3 project decentralization. At the same time, it might be quite a good decentralized governance process when it comes to the decisions whether or not issue the tokens and how the tokens might be issued, as this decision might be made by this decentralized community of people. However, again, in the most of the cases, it might be quite difficult to engage the right people into this DAO at the start and allow them to make such an important decisions whether or not to issue the tokens. At the same time, having the DAO company the DAO company registration after the token launch might result the broader community of people who might be involved into the DAO decentralized governance. And as there will be some token holders who will be motivated to make as better decision as possible for the DAO, And that's why the decisions might be made also in a better way or in the DAO, which is registered after the token launch event. However, at the same time, in this case, the event of the token issuance and token initial distribution should be covered in a more centralized way, which means that it will be controlled by the separate group of people like investors, founders, the team, etc., which might be not very transparent for the community. However, at the same time, considering that this is super important decisions, it might be better to cover it in a more centralized way, and after that structure the DAO company. But again, from the legal perspective, both options might work, and that's more like a business decision. However, when we speak about this dilemma of the capitalization, having the DAO company before or after the DAO launch might affect this valuation questions. And the main question is about the investors' expectations. As if we speak about the Web2 startups, the main expectations of the Web2 investors is to receive shares which will grow in their value in the future, and also to take some level of control over the company, for example, in the form of sitting on the board of the directors. It's a bit different in the Web3 investments, where the main investors' expectations are related to the tokens, and at the same time, where the DAO membership provides the investors the possibility to become the part of DAO community and become the DAO member with some specific voting, with some voting rights, which will be probably equal to the voting rights of all other DAO members. And this is also the different way and the different approach how the investors' right of control might be structured in the Web3 organization. So that's the general overview of the main differences between the Web2 and Web3 fundraising. We also discussed these different stages of Web3 company development, which stages of fundraising might be the most relevant on each stages of this Web3 product development. We also discussed the packages of the documents for the due diligence on each of the stages, and different types of investment documents which involve this tokens, future or existing one, and how it might be structured on each of the fundraising stages. And in the end, the very important question that might affect the strategy of the Web3 project is related to the project valuation. It's very important to the Web3 founders to decide which kind of asset they would like to use as the core asset for company valuation and company capitalization in the future, and how it will affect the investors' expectations, and as a result, how the investors might expect it to be reflected in the investment documents. So that's all for today. I would like to thank you very much for your attention, and also make a brief announcement that on this Thursday, we will have our last webinar from this series of legal webinars for the Web3 founders. We will cover the topic about the DAO legal structuring. We will discuss different governance models, different types of DAO governance bodies, different types of DAO business models, and how it might affect some regulatory compliance, and the role of our company in this whole legal structure of Web3 projects. So you're very welcome. Please feel free to come to our website and register to this webinar. We will be very happy to have you there, and also to discuss with you this super interesting topic. The last suggestion is to book the legal session in case you might be interested in one-to-one session to discuss your specific plans to structure your own Web3 project. whether it's related to the fundraising or to the intellectual property structuring or to the dev company registration or to the tokenomics. We'll be very happy to have this call with you and help you to navigate around these different legal frameworks and legal concepts for Web3 legal structuring. That's all for today. I would like to thank you again for your attention. I hope it was helpful, and sorry for these technical issues at the start of the webinar. And we can move to the second part of the webinar and discuss briefly the questions from our auditor, from our attendants today. I'll start from the first question, and this question is as follows. Is it possible to issue tokens, fundraise, and not to create a DAO company? Is it a must for the Web3 project? Thank you very much, Andy. That's a very good question. And as was mentioned previously, the DAO company and the stage of DAO launch is not the necessary stage for every Web3 startup. It's more about the Web3 founders' strategy, long-term strategy. Some of the Web3 founders would like to keep the control over the company, and they would like to control the token issuance, token allocations, token distributions. They would like to also control their product and decide by themselves what should be the business model, what should be the commissions, etc., etc. In this case, it will probably be not relevant for such kind of founders to register, to create a DAO and register the DAO company, because there is no necessity to create this decentralized governance model and to transfer the ownership of the project, of the protocol, and of the protocol's assets and treasuries to the community. That's why it's probably possible to fundraise and to structure the project without this last third stage of DAO launch. And this will not require this additional legal works related to the decentralized governance and decentralized ownership. However, if the Web3 founders would like to create the product, launch the protocol, issue the tokens, and at some stage of project development, transfer all the assets and all the control over the project and over the protocol to the community to make it like more open source, more decentralized, and to follow this concept of permissionless and ownerless decentralized organizations. And in this case, it might be relevant to think about the DAO company and to structure the DAO, to structure it as the governance wrapper to protect this group of people who will be involved into the decentralized governance and treasury management as the DAO members, and who will vote for some specific decisions, make proposals, etc. We will cover this in more details on our next webinar. So I'm happy to invite all our attendants to visit our next webinar on this Thursday, because this webinar will be exactly about the DAO, its role in the whole Web3 product ecosystem, and also some legal details of this DAO legal structuring. We also have another question, which is as follows. Is it possible to get a controlling stake of tokens of DAO company to have more rights than other DAO members, like the Web2 company or IT company? That's a really good question. Thank you very much for this. And this is possible for sure, technically. But this is more about the tokenomics, which we discussed on our previous webinar about the tokenomics and token distribution plan. When it comes to creating the tokenomics, the founders should, the Web3 founders should pay attention to these different token pools that will be allocated from the whole token issuance. And in the most of the cases, according to some common practices in token cap table structuring, the investors' pool is always no more than from 20 to 30% of all token issuance. because otherwise, if the investors will have a big stake of tokens, they might make some impact onto the token price when the tokens become liquid on some third-party platforms like exchanges or some liquidity protocols. And that's the risk for tokenomics of every Web3 startup. That's why the founders need to control and to also consider it from the strategic point of view, how they would like, how big token allocation for investors they would like to put into their token cap table, as this might affect in the future the tokenomics and make a lot of risks and damages for some other ecosystem participants and some other token holders who might have the smaller token stakes inside the DAO. Cool. So thank you again for the questions. They were really super interesting, and I'm happy to provide this feedback on it. Hope it's helpful. I'd like to remind you again that will be very happy to see you on our last webinar from this legal series of webinars, which will be about the DAO legal structuring and how to follow this decentralized concept and at the same time to create the proper legal structure to protect the DAO members. So you're very welcome and hope to see you on this next webinar. And I would like to thank you again for your attention on this webinar. I hope it was helpful for you. Thank you very much for the questions and wish you a nice evening. Goodbye.